for Matuga, Honorable Tandaza Sawa. So I'll give this chance to the member, to the chairperson of the Committee on Transport and Infrastructure. Honorable Zahir, I'm told you are in charge of this. Honorable Zahir Janda, I'm told you're in charge of this. Are you?
Thank you, Honorable Chair. I'd like to make a response to a statement on behalf of my chair of the Transport and Infrastructure Committee.
So,
Honorable Chair.
Order. I'm informed that the Honorable Tandaza is not in the House. I don't know that he assigned that to any other member. If not, then you pen the question. You table the, he will look at it when he comes to the House next.
Honorable Speaker, I also have a statement for...
Yes, we're going to do that one next. The member for Saboti. Member for Saboti in the House. Honorable Hamisi. These responses will be tabled accordingly, and members thereof lose any right to come and demand for them on the floor of the House. So the responses to those two questions have been tabled by the member, by the chairperson of the Committee on Transport and Infrastructure, and will be dealt with accordingly. Thank you. So, all the members, there is a statement to be raised under standing order for the three by the Honorable member for Bomet, Honorable Lynette Toto. This is your opportunity.
Thank you, Mr. Speaker, for giving me this opportunity to make a statement, a general statement regarding statement of healthcare services at Longisa Referral Hospital in Bomet County. Honorable Speaker, pursuant to the provision of Standing Order 43, I rise to make a statement regarding the tragic death of a young girl, Diana Chepkemoi from Tendwet, Village Bomet East constituency. This is due to medical negligence at Longisa County Referral Hospital. Mr. Speaker, it is with profound sadness that I bring to the attention of this House the untimely demise of a young girl named Diana Usagam to P. Phenom complication due to medical negligence. On 10th of November 2024, a distressing incident occurred where Diana was stung by bees and rushed to Longisa Referral Hospital for emergency treatment. On arrival, she was left unattended for more than 5 hours at the hospital with reports of demands for payment during a life-threatening emergency. Sadly, she lost her life while being transferred to Tenwek Hospital for special treatment. This incident represents a violation of constitutional right to the highest standard of health as enriched in Article 43, 1A of the Constitution. Honorable Speaker, this tragic incident has also exposed deeper systematic issues within our healthcare system. The Medical Practitioners and Dentists Act, alongside other health regulation, places a duty on healthcare professionals to provide urgent care. The tragic loss of the young girl at Longisa County Referral Hospital is heartbreaking and ought not to happen again. Honorable Speaker, as we seek justice for Diana's family and accountability for this tragic loss, I urge this House to consider immediate intervention to address these systematic failures. The people of Bomet County, and indeed all Kenyans, deserve access to quality healthcare services delivered by professionals in well-equipped facilities. We must ensure that such preventable losses of life do not recur in our health institution. Thank you, Mr. Speaker. I wish to donate my minutes to the county, to Member of Parliament, Richard Yegon. Thank you, Mr. Speaker.
You have any minutes to donate to anybody. Honorable members, you've heard what the Honorable Toto says happened at Longisa. All of us watched news in horror. We'll not debate this, but I'll give a chance to the member for Met East to say something. And before we...
Thank you very much, Mr. Speaker, for giving me this opportunity also to talk about the incident which happened in my constituency. Honorable Speaker, may I take this opportunity to sincerely convey my heartfelt condolences to the family of the young innocent child. Honorable Speaker, this tragic incident underscores the troubling silence from the county government of Bomet, which has yet to release any statement on this matter, despite the fact that the incident occurred at the County Referral Hospital. In times of such sorrow, Mr. Speaker, and injustice, the public rightfully expect accountability and transparency from their leaders. The absence of the response from the county government adds to the pain of this loss and raises concern about the oversight and responsibility within our healthcare facilities, Mr. Speaker. In Diana's memory, it is crucial that the authorities conduct a full investigation, identify those responsible, and enact reforms to ensure such tragedy does not happen again. Upholding the Constitution right to health care as stipulated in Article 43(1)(a) means addressing the systemic issues head-on and committing to an equitable, responsive healthcare system for all citizens. Mr. Speaker, I wanted to add this. Where is the CEC? Where is the CEO? The hospital superintendent of the County Referral Hospital? Where is the governor? It is only that they are going into the radio stations, calling radio station, Mr. Speaker, to complain to the members of parliament who are in Nairobi here. We are raising a lot of concern with the issues which is happening in the County Referral Hospital. County Referral Hospital should be taken as a crime scene, Mr. Speaker. Longisa Referral Hospital, Mr. Speaker, has in many cases shown that there is a lot of problems in that hospital, and there is nobody who is trying to address. We want the county official led by the governor himself, the CEC, and the CEO of Health for Bomet to be taken into account for this loss of the child, Mr. Speaker. I thank you, Mr. Speaker. Thank you so much.
Thank you. Honorable members, I think that marks the end of statement of questions, but I'm being moved by the chairperson of CDF committee that he has an announcement to make. He will have 3 minutes to do so, or less, before we go to the next order.
Thank you, Mr. Speaker, for giving me this opportunity. I want to give the announcement that Treasury finally today has released the balance of the CDF money, 5.7 billion, which was due, and we are expecting to get the next balances for the start of the financial year 2024-25 from December. So I want to ask members, as you go back to your constituencies, please make sure you do also ask your committee to do audits to make sure that there is no money remaining in the board which is due for development to their constituencies. The more they stay here, the more we lose as members, or your constituents lose a lot, because we require you to finish these grade 9 classroom, grade 9 report to school. They do not go under trees. They will go to classes which have been done by the National Government Constituency Development Fund. So I want to wish each one that may you do a good job and submit your proposals as soon as possible for 2024-25 financial year. Thank you, Mr. Speaker.
Thank you. The member carrying his hands up. Don't you have a card? We cannot see you. Go ahead. We cannot see. You don't have a card.
Oh, thank you, Mr. Speaker, for the opportunity. And sorry, I want to take you back a bit on the request for statements that have been made by my colleagues regarding the human-wildlife conflicts. Mr. Speaker, in the month of September, I think around 18th there.
Order. The Honorable Kawanjiku, the member for Kiamba. This question or the statement being raised by the member on his feet is for you.
Thank you, Mr. Speaker. On the 18th of September, or thereabout, I did ask for a statement in this floor of the House regarding the human-wildlife conflict in Bamba and Ganze constituency. I had said that we are suffering an invasion by elephants who have left the Tsavo East National Park, and they have invaded areas where people are living. And the chairman of the committee had promised me that he will be giving a statement in this House in 2 weeks' time. But up to now, it's around almost 2 months, and we have not had anything from the committee. So, Mr. Speaker, I was asking for direction on what we need to be done, because as it is right now, the situation in Ganze is even getting worse, and it really needs an immediate intervention by the government. Thank you, Mr. Speaker.
Yes, the Vice Chairperson, Committee on Tourism and Wildlife.
Thank you, Mr. Speaker. I think I will fast track. I would really want to apologize on the behalf of my chair if the report has not been tabled in the floor of the House, but I think the report is ready. We seek your permission, Mr. Speaker, that by the end of this week or early next week, Tuesday, we'll have tabled the report before the floor of this House, Mr. Speaker.
This report to be tabled on Thursday this week, Thursday afternoon.
Thank you, Mr. Speaker. Well guided.
Thank you. Next order.
Order number 8, the Kenya Roads Board Amendment Bill, National Assembly Bill number 18 of 2024. Second reading, question to be put.
Oh, members, debate on this bill, the second reading stage was concluded, and this therefore is a decision to make. Therefore, put the question that the Kenya Roads Board Amendment Bill, National Assembly Bill number 18 of 2024, be now read a second time. Will, as many other opinions say aye? Will, as many other opinions say nay? Ayes have it.
A bill for an act of parliament to amend the Kenya Roads Board Act of 1999. Order number 9, the Tea Amendment Bill, Senate Bill number 1 of 2023, first reading. A bill for an act of parliament to amend the Tea Act to provide for direct sales of tea, the payment of tea proceedings, and for connected purposes.
Next order.
Order number 10, the Maternal, Newborn, and Child Health Bill, Senate Bill number 17 of 2023, first reading. A bill for an act of parliament to provide for coordinated system for provision of quality maternal, newborn, and child health services, to provide for response to maternal and child morbidity, and motivates the attainment of health rights for mother and child, and for connected purposes.
Honorable members, before you go to the next order, I got a communication to make regarding Boruku. Don't Boruku. Oh, members, this is a confusion regarding the withdrawal of specific provision contained in the statute law, Miscellaneous Amendment Bill, National Assembly Bill number 67 of 2023, which we'll consider shortly in the committee of the whole House. Honorable members, as you may be aware, the statute law, Miscellaneous Amendment Bill, National Assembly Bill number 67 of 2023, was published via Kenya Gazette Supplement number 0206 of 30th October 2023 to effect various amendments to 9 statutes. The bill, which is sponsored by the Leader of Majority, was read a first time on 15th November 2023, and thereafter the bill was referred to various departmental committees for consideration of relevant provisions in accordance with the respective mandates, with the lead committee being the Departmental Committee on Legal Affairs, Justice and Legal Affairs. The committees tabled their respective reports on the bill in the House on 15 February 2024. Thereafter, the bill was considered and passed by the House at second reading on Wednesday, 12th June 2024, and committed to a committee of the whole House. Indeed, as you may be aware, you have noticed, on today's order paper, the bill is scheduled for consideration in the committee of the whole House under order number 11. Honorable members, before the House proceeds to consider the bill in the committee of the whole House, I wish to notify the House that I have since received a request from the sponsor of the bill, that is the Leader of Majority Party, via a letter dated 11th November 2024, seeking my consent for the withdrawal of the proposed amendments relating to sections 186, 4, and 6F of the Children's Act, Cap 141, as contained in the bill. The amendments proposed the deletion of provisions which prohibit the court from granting a sole male applicant and foreign applicant adoption of a child. In the letter, the Leader of Majority states that the import of the proposed amendments to the said provisions necessitates further consultations and engagements with relevant stakeholders. Honorable members, having considered the justification by the Majority Leader, I have acceded to his request to withdraw the provisions relating to section 186.4 and 6F of the Children's Act, Cap 141, as contained in the statute law, Miscellaneous Amendment Bill, National Assembly Bill number 67, 2023. In this regard, the bill will therefore be proceeded with the committee of the whole House without reference to the withdrawn provisions and will be considered as though the withdrawn provisions was not part of the bill ab initio. The House is accordingly guided. Thank you. Next order.
Order number 11, Committee of the Whole House.
Thank you, honorable members. You may take your seats as we go to the committee of the whole House. And please, I would advise you stick. The omnibus is usually a very important bill, and your interest must be inside here. Okay. Very well, honorable members, we want to consider the statute law, miscellaneous amendments, bill, National Assembly Bill number 67 of 2023. Okay, honorable members, following the Speaker's direction, we are not going to consider the provisions relating to the Children's Act number 29 of 2022 as directed by the Speaker because it's already withdrawn by the Leader of Majority.
It's okay. Schedule. Provisions relating to the Copyright Act, number 12 of 2001.
Very well. Was the question that provisions relating to the Copyright Act number 12 of 2001 be amended as proposed in section 2. There's an amendment to this, and therefore I bring the chair. Which chair is the Copyright Act number 12 of 2001? Chair Sports, very good in the House. Proceed, Chair. Give him the mic.
Thank you, Honorable Chair. I beg to move that the schedule to the bill be amended as it appears in the order paper. The justification, or before I get there, is by deleting the proposed amendments to section 2. The justification, Chair, the bill proposes to amend the definition of the term collective management organization so as to include the negotiation of license fees as one of the objects of the collective management organization. Section 33(9) of the Act provides that a license to copyright work may be granted by the owner of the copyright. Further, Section 33A of the Act...
Order, Honorable Chair. Let's deal with Section 2, and then we shall give you a chance.
Thank you.
Very well, honorable members, I propose the question that Section 2 be amended as proposed by the Chair. I now put the question that section 2 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. Honorable members, I now put the question that the provisions relating to section 2 be part of the bill. Will as many of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
New section 30AA.
I propose the question that the provisions relating to the new section, I'll take it again. I now propose the question that provisions relating to the Copyright Act number 12 of 2001 be amended as proposed in the new section 30A. Chair.
Chair, I beg to move that the schedule to the bill be amended as it appears in the order paper, that is by deleting the proposed new section 30AA. The justification: the bill proposes to insert a new section 30AA into the Act, which provides for the regulation of equitable remuneration of performers and producers in a sound commercial. In terms of this amendment, the user of the commercial shall be paid an equitable remuneration to be divided in half by the producer and the performer. The amendment provides for the payment of equitable remuneration of only performers and producers of sound recordings on a 50-50 basis, and this leaves out any other players that may be involved in the creation of the sound recording. Further, formula for the sharing of the remuneration should not be contained in the Principal Act, but may be provided for in the subsidiary legislation.
Mike.
And further, Chairman, as I conclude, the High Court in the Constitution Petition number 5 of 2016 in Malindi ruled that Section 30A of the Copyright Act, being the proposed new Section 30AA, was unconstitutional because it limited the rights of the artists to choose how their royalties are to be paid, and therefore limited their freedom of association.
Honorable members, I now propose the question that section 30AA be deleted as proposed by the chair. Honorable members, I now put the question that section 30AA be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. That was a deletion, so we proceed.
Section 30B.
Honorable members, I propose the question that the provisions relating to the Copyright Act number 12 of 2001 be amended as proposed. Section 30B. Chair.
I beg to move that the schedule to the bill be amended as it appears in the order paper in the proposed amendments to Section 30B. 1, by deleting the proposed amendment to the subsection 1. 2, by deleting the proposed amendments to subsection 2. And 3, by deleting the proposed amendments to subsection 3. Justification, Chair. The bill proposes to amend Section 30B of the Act to include orders under the ambit of collection of royalties by the Kenya Revenue Authority or any other entity designated by the Kenya Copyright Board. While the committee noted that this amendment would serve to include orders in the collection of royalties by the Kenya Revenue Authority, the committee agreed with the submissions of the Kenya Copyright Board to withdraw the amendments to allow for the stakeholders' engagement to ensure that all relevant categories of rights are included in the provision. I submit, Chair.
Very well, honorable members. I now propose the question that section 30B be deleted as proposed by the chair. I now put the question that section 30B be deleted as proposed by the chair. Will as many as of that opinion say aye? Will as many as of contrary opinion say nay? The ayes have it. I now put the question that section 30B be I'll take it again. I now put the question that section 30B relating to the Copyright Act, Cap 12 of 2001 be deleted as proposed by the chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Section 46.
I propose the question that provisions relating to the Copyright Act, number 12 of 2001, be amended as proposed in section 46. Chair.
Thank you, Chair. I beg to move that the schedule to the bill be amended as it appears in the order paper in the proposed amendments to section 46. 1, by deleting the proposed amendments to the subsection 1. 2, by deleting the proposed amendments to subsection 3. Then 3, by deleting the proposed amendment to subsection 4. And this is the justification, Chair. The bill proposes to amend section 46(1) of the Act to provide for the requirement of an operating license issued by the board in addition to a registration certificate for a person or association of persons to carry on business of collective management organization. The committee further noted that the requirement of the both registration and operating license may lead to the bureaucracy within the creative arts sector. The committee noted that the proposed amendments to extend the validity period for a registration certificate issued to a collective management organization from 12 months to 36 months may be a welcome provision. However, the Kenya Copyright Board requested that the amendment be withdrawn from the bill to allow for further consultation with all the relevant stakeholders. Chair, the proposed amendments to section 46(4) to provide that the board may approve a collective management organization if it is satisfied that the body is a company limited by guarantee and incorporated under the Companies Act of 2015, and that additionally, the company is registered as a collective management organization by the board, amounts to a conflict and would amount to increase in bureaucracies in the registration of the collective management organization. Finally, Chair, the proposed new subsections, providing that where a collective management organization license is revoked, the board shall appoint an agent to hold monies until the license is reinstated or a new organization is licensed by the board would result in implementation and accountability challenges. I submit, Chair.
Honorable members, I now propose the question that Section 46 be amended as proposed by the Chair. Honorable members, I now put the question that Section 46 be amended as proposed by the Chair. Will as many as of that opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Section 46A.
Honorable members, I now propose the question that provisions relating to the Copyright Act number 12 of 2001 be amended as proposed. Proposed in section 46. Chair.
I beg to move that the schedule to the bill be amended as it appears in the order paper by deleting the proposed amendments to section 46A. Justification, Chair, the bill proposes to insert new subsection into section 46A, which provide for the power of licensed collective management organization to appoint an agency to collect and distribute royalties on its behalf through the National Rights Registry. The amendment conflicts with the provisions of section 22C of the Act, which provides that the functions of the National Rights Registry shall be A, digital registration of the right holders, B, digital registration of the copyright works, C, authentication and authorization for consumers of rights works, D, media monitoring registered copyright works, E, tracking, monitoring, and the dissemination of data or logs related to access of registered copyright works, and finally, any other functions that may be assigned by the board. The National Rights Registry is not involved in the collection and the distribution of royalties. I submit.
Honorable members, I now propose the question that section 46. We have done that one. Honorable members, I now propose the question that provision relating to section 46 be amended as proposed by the mover. Honorable members, I now put the question that section 46 be amended as proposed by the mover. Will as many as of that opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Section 46A.
He has already done that one, so move to section 46B. Chair, deal with both A and B. We are done with 46.
I beg to move that the schedule to the bill be amended as it appears in the order paper by deleting the proposed amendments to section 46B. Justification, Chair, the amendment inserts a new subsection 1A, which seeks to give power to the board of directors of a collective management organization to co-opt persons with professional expertise. This amounts to micromanaging the CMOs by directing in legislation how they should conduct their management affairs. The proposed new subsection 5 is not necessary as it is a restatement of the provision of Regulation 16C of the Copyright Collective Management Regulation, which provides that a general meeting shall decide the appointment and dismissal of the organization's officials, review the officials' performance, and approve their remuneration and other benefits. The proposed new subsection 6, 7, and 8, which provide that a person convicted of an offense shall not be eligible to be appointed as a board member or staff of a collective management organization, may be contained in the CMO's constitutions, noting that CMOs are private entities. Chair, I beg to move that the schedule to the bill be amended as it appears in the order paper by deleting the proposed amendment to section 46C. Justification.
Order, Chair. You have moved all the way to C, but we had called out A and B.
Thank you,
So
Chair.
allow me to put the question. Honorable members, I now propose the question, not put the question, but I now propose the question that sections 46A and section 46B be amended as proposed by the chair. Yes, let's hear Honorable Undo on this one.
Chair, I just need a bit of clarification from the chair, because looking at subsection 46A, Chair, it relates to the appointment of an agency approved by the board to collect and distribute royalties on their behalf through the National Registry, Rights Registry. Yet what the chair has basically related to actual results is under section 46B. So I was just wondering, how does he treat section 46A in view of the proposed amendment? Probably can tell us the justification, because the justification as given relates to 46B. I want him to give us justification in relation to 46A.
Proceed, Chair, and give that justification.
Honorable Chair, this justification of section 46A, the bill proposes to insert new subsection into section 46A, which provide for the power of a licensed collective management organization to appoint an agency to collect and distribute royalties on its behalf through the National Rights Registry. And I went further, say the amendment conflicts with provision of section 22C of the Act, which provides that the functions of the National Rights Registry shall be, and I tabulated the same, Honorable Chair.
Very well. Honorable members, I now put the question that sections 46A and B be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Section 46C.
Chair. Oh, let me first propose the question that provisions relating to I'll take it again. Let me propose the question that was in section 46C. Chair.
I beg to move that the schedule to the bill be amended as it appears in the order paper by deleting the proposed amendment to section 46C, and the justification is the provisions contained in the proposed new subsection 1A are already contained in the current section 46(5) of the Act, which provides that the board shall not approve another collective management organization in respect of the same class of rights and category of works if there exists another collective management organization that has been licensed and functions to the satisfaction of its members. There is therefore no need to restate the provision. I submit, Chair.
Very well, I now propose the question that section 46C be amended as proposed by the chair. I now put the question that section 46C be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Section 46E.
I propose the question that the provisions relating to the Copyright Act 2012 of 2001 be amended in section 46E as proposed. Chair.
I beg to move that the schedule to the bill be amended as it appears in the order paper by deleting the proposed amendment to section 46E. Justification, Chair, the proposed new paragraph H, providing for inspection of a collective management organization by the board at any other time that the board considers appropriate, may be subject to abuse since the specific circumstances in inspection are already set out in section 46E6 of the Act. The Act already gives to the board to inspect the accounts of collective management organization. Therefore, it is not necessary to restate the same. I submit, Chair.
Very well, honorable members. I now propose the question that section 46E be amended as proposed by the chair.
What's the question?
Honorable member, yes, Honorable Undo.
Chair, I would request the chair probably also give an insight, because if you are deleting the entire 46E, yet it had section 7, subsection 7, and subsection 8, and this related to issues of accounts and the rest. Probably you could also explain to us, does it also mean the two remaining subsections also are deleted, and yet you have not spoken to it? Thank you, Chair.
Chair.
Chair, the sections that have not spoken to them, they therefore remain. We have only amended the ones we feel are not necessary. I submit, Honorable Chair.
Honorable Wundo, what is it again?
Chair, if you look at the order paper, H says by deleting the proposed amendments to section 46 has got several. So that's what we want to understand, that it cannot be said that what he has not spoken to is not being amended, yet the adding on the order paper is deleting the proposed amendment section 46E, which contains several subsections. So the implication of what is here and what he's saying are completely different things. That's why we need to be very clear. Are we amending the entirety, and yet he has not given justification for deleting subsection 7 and subsection 8? That's what I'm just seeking clarification.
He has heard you clearly. Chair, you could speak on that.
Whatever, and I want to submit, Chair.
Yes.
That we have only touched on what we feel is erroneous in these sections. And therefore, that's why we have only given the justification on H, because that is what interferes with the amendments as they appear.
So which specific ones have you touched on, just for record purposes?
We have only amended section H.
Very well, so that we are able to move on and just approach the table, Chair, for 1 minute. Give me the mic. I also advise that the chair, you sit somewhere near here, because those regular consultations are important, especially with the councils, and then you proceed. Very well, Chair. You could just speak on that one now for only 1 minute, just to make sure that the House is clear about the consultations you've been having with the leader of majority leader. And
Honorable Chair, we intend to delete the whole section 46E because it is already provided for in the Act.
Very well, honorable members. I now put the question that section 46E be amended as proposed by the chair. I now put the question that section 46E be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. Honorable members, I now put the global question, which is that the provisions relating to the Copyright Acts number 12 of 2001 be deleted. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I further advise that if you are chair, you are having more amendments, you move closer. Okay, very well, you are through with your section. We proceed.
Provisions relating to the Scrap Metal Act 2015, number 1 of 2015. Section 2.
Honorable members, I propose the question that provisions relating to the Scrap Metal Act 20, I'll take it again. Honorable members, I propose the question that provisions relating to the Scrap Metal Act number 1 of 2015 be amended as proposed in section 2. Chair.
Chair, I beg to move that the amendments as appearing in the Scrap Metal Act, as it appears in the order paper, be amended as it appears in the order paper. And the justification for that, Chair, is that the proposed amendment is necessary to bring clarity to the definition of the word scrap metal.
Proceed to move the second part of it.
Chair, I propose to, I beg to move that the amendments as appears in that order paper on the second part be amended as appears on the order paper. And again, the justification is that the word platinoid group has been used in the definition of scrap, and as such, it is proper for the word to be defined to clarity on the types of metals that fall within the platinoid group.
Very well, honorable members, I now propose the question that section 2 be amended as proposed by the chair. There's an interest in this. Yes, the Honorable Archie.
Chair, when I look at the Act and I look at the amendments, while I appreciate the Chair, then it would have been better if you want to give clarity to scrap, to now explain to Kenyans to understand better, because you realize the distractions we are having right now, even in the metals we put on the roads everywhere, it is just so sad. But when you just say scrap, then it will continue being the same challenge. So if it is for clarity, they understand. They know there's a Scrap Metal Act, so then clarity on what?
Let's hear. The majority leader.
Thank you, Honorable Chair. I think just to make it clear to Honorable Elachi, the definition of scrap metal is already contained in the Act. And in actual sense, what the Chair is trying to do now is to delete the words of used automobile. For instance, you discover in almost all parking yards in government offices, they are used automobiles. Therefore, if you use used automobile as a scrap metal, people will go and park cars today and tomorrow they will sell them as scrap. That is why the definition now within the definition for scrap metal for used automobile is being deleted to now use the word discarded. A discarded automobile that is not in use. Otherwise, if you say a used automobile, even my own car, because it came second-hand from Japan, is a used automobile. And somebody might just declare it as a scrap metal and sell it as scrap metal. Therefore, that was the clarity of that definition. To Honorable Chair, I think it's also good to include the exact definition of what is constituted of platinoid groups. Platinoid group, Honorable Speaker, as the Chair has enumerated. If you look at the import of many of these amendments, and those who sit in the House Business Committee, including yourself, Chair, will remember just this afternoon, the Honorable Chepkonga raised the issue of copper. And we had indication that there was indeed a bill that was defining, that was limiting who would trade in scrap metal that relates to copper and aluminium. And these amendments are actually in these miscellaneous statutes, that it will now be possible to protect our transformers, our other installations, including rail guards that are made some from aluminium, and people vandalize this critical government infrastructure, including transformers. And this afternoon, the Honorable Chepkonga was just speaking about how many of our constituents are suffering from transformers that have been vandalized, largely because people are looking for copper windings that are inside those transformers to sell as scrap metal. Therefore, with the enactment of this legislation, it will now be possible to protect even our transformers and other critical infrastructure, Honorable Speaker, and I therefore support those amendments.
Thank you, Majority Leader, and I think that explanation now comes out. Even from where I'm seated, I'm very, very much now clear. And I hope, Honorable Elachi, it's clear to you. Honorable members, I now put the question that Section 2 be amended as proposed by the Chair. Will as many as of that opinion say aye? Aye. Will as many as of contrary opinion say nay? The ayes have it.
Section 4(1).
Honorable members, I now propose the question that provisions relating to the Scrap Metal Act, number 1 of 2015, in section 4(1) be amended as proposed.
Honorable Chair, I beg to move that section 4(1) be amended as it appears in the order paper. And the justification for that amendment, Chair, is that it is necessary to include the principal secretaries for finance and internal security as members of the Scrap Metal Council, since the two have been excluded in the Principal Act, yet they have a critical role to play in matters policy formulation, that will assist the Council in developing appropriate measures and mechanisms for regulating the scrap metal industry and ensuring economic growth, protection of public health, and conformity to the principles of environmental stewardship as required by the Basel Convention as provided under Section 6.1 AI and of the Scrap Metal Act. And that is very necessary, especially now that we need to protect our assets. Thank you, Chair.
I propose the question that section 4.1 be amended as proposed by the chair. In the absence of interest, honorable members, I now put the question that section 4.1 be amended as proposed by the chair. Will as members of that opinion say aye? Aye. Will as members of the contrary opinion say nay? The ayes have it.
Section 4.1F1 and section 4.1F5.
There are no amendments on this one, and therefore, honorable members, I propose the question that the provisions relating to the Scrap Metal Act, number 1 of 2015, be amended as proposed in section 4.1F1 and section 4.1F5. Because there are no amendments, honorable members, I proceed to put the question, which is that section 4.1F1 and section 4.1F5 be amended, be part of the bill. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
Section 6.1A2.
Honorable members, I propose the question that the provisions relating to the Scrap Metal Act, number 1 of 2015, be amended as proposed in sections 6.1A2 of the bill. There being no amendment, I now put the question that section 6.1A2 be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Section 9.1.
Honorable members, I propose the question that provisions relating to the Scrap Metal Act number 1 of 2015 be amended as proposed in section 9.1. And there being no amendment, honorable members, I now put the question that section 9.1 be amended, be part of the bill. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
Section 11.
I propose the question that provisions relating to the Scrap Metal Act number 1 of 2015 in section 11 be amended in clause 11 as proposed in the bill. Equally, there's no amendment. I now put the question. Is there an amendment? Very well, Chair, there is an amendment in section 11. So proceed, Chair.
Chair, I propose that the amendment in section 11 is to propose the amendment to the deletion of the proposed amendment to section 11. And the justification for this, Chair, is that the opinion of the committee was that the provision encourages dealing of copper, aluminium, and the alloys, which form part of what we call the critical national infrastructure. And as such, it will be improper to make a provision for issuance of special license for dealing in alloys that form part of critical infrastructure.
Honorable members, I propose the question that section 11 be amended as proposed by the chair. Any interest, Honorable Oundo?
Chair, I just also want to support. I sit in the committee and we deliberated on this matter at length. And basically, Chair, is to cure the discretion that was going to be given to the Cabinet Secretary to do things, to give licenses that's going to deplete our critical infrastructure. Because we have seen in the past, Honorable Speaker, when such discretion is given to a human being, the tendency to abuse or misuse is very compelling and should never give room for such kind of discretion. Thank you, Honorable Chair.
Honorable Gishimu.
Thank you, Chair. As I support this proposal by the committee to delete any provision delegating powers to make law can only be through this parliament, either through an act of parliament or through a regulation. So giving the cabinet secretary open powers, role of parliament to make law. Thank you.
Very well. Honorable members, I now put the question that section 11 be deleted as proposed by the chair. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Section 18.3A, 18.3B.
Honorable members, I propose the question that provisions relating to the Scrap Metal Act number 1 of 2015 be amended as proposed in clauses 18.3A and 18.3B. Because there are no amendments, I proceed to put the question that clause, I proceed to put the question that sections 18.3A and sections 18.3B be part of the bill. Will as many as of that opinion say aye? Aye. Will as many as of a contrary opinion say nay? The ayes have it.
Section 24.
Honorable members, I propose the question that provisions relating to the Scrap Metal Act number 1 of 2015 be amended as proposed in section 24. And there being no amendment, honorable members, I now put the question that section 24 be part of the bill. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
Section 22.2, Section 24, Section 24.2, and Section 26.1.
Thank you, honorable members. I bring to the Scrap Metal Act number 1 of 2015 be amended as proposed in section 26. Act number 1 of 2015 be amended as proposed in section 26.2. There's an amendment to this, Chair.
Thanks, Chair. I beg to move that section 26.2 be amended as it appears in the order paper. And the justification for this, Chair, is that the amendment is necessary to give effect to the proposed amendment under section 26.1, which gives the Cabinet Secretary power to authorize export or import of specific scrap metal. And section 26.1 is also amended to prohibit export or import of scrap metal unless authorized by the Cabinet Secretary responsible for industrialization. As such, the committee proposes to allow the export of scrap, export or import of scrap, of specific scrap metal for specific purposes. Thank you, Chair.
I propose the question that section 26.2 be amended as proposed by the Chair. Yes, Honorable Gichimu.
Thank you, Chair. Actually, this cures the intention that had been intended in the amendment of section 11, whereby any action by the Cabinet Secretary for internal security, for matters relating to finance, and also in consultation with the council, will have to prescribe
prescription in law means there have to be regulations so that we can be able to restrict. Even this parliament will also have a say in determining what kind of metals can be given licenses for importation or exportation. Thank you, Chair.
Yes, Honorable. That's Honorable Watch.
Thank you, Honorable Chairs. I support the proposed amendment with the rider and hoping that this is subject to provisions of 94(5) relating to the powers of Parliament, that nobody has the power to make law other than Parliament, as adverted by my colleague, that the committee that deals with the delegated legislation will also be able to have a bite at the decisions of the CS for Finance and the other relevant CSs. Otherwise, I support. Thank you.
Honorable members, I now put the question that section 26(2) be amended as proposed by the mover. Will as many as without opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Section 26(3), Section 26, Section 31A, Section 31E2.
Honorable members, I propose the question that provisions relating to the Scrap Metal Act number 1 of 20 posts in sections 26(3), 26, 31A, 31E2. There being no amendments on this one, I proceed to put the question that sections, will as many as without opinion say aye? Will as many as with a contrary opinion say nay? The ayes have it. I now put the global question, which is that provision relating to the Scrap Metal Act number 1 of 2015 be amended, as amended be part of the bill. Will as many as without opinion say aye? Will as many
Provisions relating to the National Employment Act number 3 of 2016. Section 2, Section 4, Section 9C, Section 17(2), Section 28(2), Section 31.
Honorable members, I propose the question that provisions relating to the National Employment Authority Act 2016, number 3 of 2016, be amended as proposed in sections 2, sections 4, sections 9C, sections 17(2), sections 28(2), sections 31. There being no amendments, honorable members, I proceed to put the question that sections 2, sections 4, 9C, 17(2), 28(2), and 31 be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Section 32.
I propose the question that provisions relating to the National Employment Authority Act 2016, number 3 of 2016, be amended as proposed in section 32. Is there an amendment? Yes. The Labour Committee Chair.
Thank you, Honorable Chair. And I beg to move that the schedule to the bill be amended by deleting the proposed amendment to the section 32 of the National Employment Authority Act. And Honorable Chair, the justification is that that section does not contain the word youth, and the intention was to replace the word youth with a jobless, with the word jobless. So that section does not contain the word youth, and that is the justification.
Very well. I propose the question that section 32 be amended as proposed by the chair. That, there being no interest, I put the question that section 32 be amended as proposed by the mover. Will as many as without opinion say aye? Will as many as were contrary opinion say nay? The ayes have it.
Section 33, Section 33(1), 33(3), 34, 36(1), 36(3), 36(4), 37, and 40. Two.
36(3), 36(4), 37, and 42 be amended as proposed in the bill. Will as many as without opinion say aye? Will as many as were contrary opinion say nay? The ayes have it. Honorable members, I now put a global question, which is that the provisions relating to the National Employment Authority Act 2016, number 3 of 2016, be as amended, be part of the bill. Will as many as without opinion say aye? Will as many as were contrary opinion say nay? The ayes have it.
Provisions relating to the Fisheries Management and Development Act, number 35 of 2016.
Honorable members, I propose the question that provisions relating to the Fisheries Management and Development Acts of 2016 post in the bill. Is there an amendment on this one? Honorable members, there being no amendment, I proceed to put the question that I'll take it again. Honorable members, I now put the question that provisions relating to the Fisheries Management and Development Act of 2016 be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. Proceed.
Provisions relating to the Energy Act, number 1 of 2019.
Amendments? Yes. Honorable members, I now propose the question.
Section 2.
Honorable members, I now propose the question that provisions relating to the Energy Act number 1 of 2019 be amended as proposed in the bill. In sections 2. No amendment? Honorable members, I therefore proceed to put the question that provisions relating to the Energy Act number 1 of 2019 in section 2 be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. Is the chair in the house? Very well, thank you.
New section 6A.
I propose the question that provisions relating to the Energy Act number 1 of 2019 be amended as proposed in section 6A. No amendments. I proceed to put the question that provisions relating to the Energy Act number 1 of 2019 be amended as proposed in section 2A. Will as many as without opinion say aye? Will as many as with a contrary opinion say nay? The ayes have it. The chair be awake to these amendments because you are the ones who are guiding us.
Section 10.
I propose the question that provisions relating to the Energy Act number 1 of 2019 be amended as proposed in section 10. Chair? Okay. Honorable Kawaya is in the house.
Thank you. I beg to move that the schedule to the bill be amended by deleting the amendment proposed to section 10 and substituting, therefore, the new amendment. Delete the words "with exception of crude oil" appearing in paragraph 2. And the import of this is that we want to give EPRA the mandate to regulate crude oil. Currently, crude oil is not being.
Honorable members, I propose the question that section 10 be amended as proposed by the chair. Yes, the Honorable.
Chair, I would just like to get a little more information as we are going on. I can see a lot of things are passing, but this sounds a very interesting bit that crude oil is now being regulated. It sounds good to me that it should be, but can we just now know what exactly is happening with the crude oil and where does it come from? What are we using it for? And so it's important for us to know that background. Because in general, it sounds a good thing. That background will help us make the decision.
Very well. Chair.
Thank you, Chair. You know, currently we have been using refined oil, but you also know we are making a lot of progress with the Turkana oil, so we are going to be having a crude oil of our own. And again, regulation also does not necessarily mean that we are using crude oil ourselves. We are likely also to have potential customers who want to use our transit lines, our pipelines to transport their crude oil. There must be some form of regulation for any crude oil arriving in the country.
Very well.
Chair, I therefore support this, but also add that, you know, we used to actually have a refinery at Changamwe. If we are going to look back and even reinstitute that and revive it, then I think that this amendment is important. I support.
Very well, you are in concurrence. Honorable members, I now put the question that section 10 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Section 12(1)(e).
Honorable members, I propose the question that provisions relating to the Energy Act, Cap 314, be amended as proposed in the clause in section 12(1)(e). Chair.
I beg to move that the schedule to the bill be amended by deleting the amendment proposed to section 12(1)(e). Chair, this particular amendment sought to remove one of the representation to the EPRA board, who is a county representative of the county governments, or a representative from the Council of Governors. As the Energy Committee, we could not see the reason why we do not need to have a representative of the county governments in the EPRA board, because considering that energy is a shared function.
By the mover. Honorable members, I now put the question that sections 12(1)(e) be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Section 21.
Honorable members, I propose the question that provisions relating to the Energy Act Cap 314 be amended as proposed in section 21.
Electricity and petroleum. And as you understand, as a energy committee, we are also working on reducing the cost of energy, and this sought actually to negate the very effort that we are doing, and that's a deletion. And further to that, I think it goes together with section 20. Their proposal was, besides increasing this or doubling these collections.
Honorable Chair, we had called out section 21. Allow me to propose the question that section 21 be amended as proposed by the chair. There are many interests here. Yes, Honorable Bowen.
Chair, I want to support the chair of the committee. Because at this difficult time, the Honorable Chair, when Kenyans are really struggling with payment of bills, especially the electricity bills, it's very appropriate for April to increase, from the 0.5 to 1, that's almost 50%. So I want to support the committee and the chair that this is not the right time. We are living at a very difficult time, and as a country, we are looking at measures on how we can reduce the cost of electricity amongst our people. Support, Honorable Chair.
Very well. There was another interest. Honorable Watch.
Chair, I support this amendment on light of the fact that the cost of electricity has a spiral effect of many other things, including the cost of living, cost of basic commodities. Flagship projects that the government has expressed itself to be in support of, like manufacturing, trade, investment, are all tied up with the cost of electricity. This includes even investors' migration. Investors have been migrating to neighboring countries because the cost of electricity in neighboring countries compared to Kenya is very, very high. And therefore, an increase in this would actually be increasing the problem rather than reduce it. So I support. Thank you.
Finally, Honorable Undo.
Honorable Speaker, sometimes we wonder where some of these people live, whether they live the pain that Kenyans go through, to have even proposed a deletion to take it to 1%, which would have increased the cost of electricity, considering that Kenya is rated as one of the countries that has the highest cost of electricity. So I totally support the committee on that proposed amendment. Thank you, Chair.
Honorable members, I now put the question that sections 21 be amended as proposed by the chair. Will as many as of that opinion say aye? Aye. Will as many as of contrary opinion say nay? The ayes have it.
Section 20.
Honorable members, I propose the question that provisions relating to the Energy Act Cap 314 be amended as proposed in section 20. Chair.
Thank you, Chair. I beg to move that the schedule to the bill be amended by deleting the amendment proposed to section 20. Honorable Chair, again, this is a bit of mischief. EPRA sought to have levies collected by themselves not be part of the consolidated fund, meaning basically this money is used raw, there's A&A, and that effectively removes, makes it difficult for us as Parliament to be able to oversight funds that are collected as A&A because they are not part of our budget.
Honourable members, I propose the question that Section 20 be amended as proposed by the Chair. Honourable members, I proceed to put the question that Section 20 be amended as proposed by the Chair. Will as many as of that opinion say aye? Aye. Will as many as of contrary opinion say nay? The ayes have it. Honourable members, as earlier on directed by the Speaker, the House was to resume at 5 to deal with matters relating to SHA and SHIF. And therefore, honourable members, at this particular juncture, would have to report progress. Very well, let me hear the point of order from leader.
Honourable Chair, I wanted to beg your indulgence that we do consider completing this because the House sits up to 7 p.m. today. And we have 2 hours, if we even push to about another 15, 20 minutes, we'll be done with this one.
You know, honourable members, the Speaker directed, and therefore let me do some consultations. Very well. Because of the direction that were given by the Speaker, we shall report progress for now, and therefore I call upon the mover, who is the leader, Majority Leader. Honourable, when we have done enough consultation, allow the Majority Leader to proceed.
Thank you, Honourable Chairperson. I would like to move that the House do report to the House its consideration of the statute law Miscellaneous Amendments Bill, National Assembly Bill number 67 of 2023, up to clause 21 of the Energy Act, and its approval thereof with amendments, and seek leave to sit again.
Mike. Honorable members, I put the question, which is that the committee to report to the House its consideration of the statute law miscellaneous amendments bill, National Bill number 67 of 2023, up to the provisions relating to the Energy Act number 1 of 2019, section 20, and its approval thereof with amendments, and seek leave to sit again. Will as many as with that opinion say aye? Aye. Will as many as with contrary opinion say nay? The ayes have it.
Chairperson to report.
Honorable Speaker, I beg to report that the Committee of the Whole House has considered the Statute Law Miscellaneous Amendment Bill, National Assembly Bill number 67 of 2023, up to provisions relating to the Energy Act number 1 of 2019, section 20, and approved the same with amendments, and seek leave to sit again.
Mover.
Honorable Speaker, I beg to move that the House do agree with the committee in the said report, and I also request Honorable Kangogo Bowen to second the motion for agreement with the report of the Committee of the Whole House.
Mr. Speaker, I second.
Honorable members, I propose the question, which is that the House do agree with the committee in the said report. The Honorable Dr. Pukose.
Thank you, Chair. The Speaker directed that the motion on adjournment be taken from 5 onwards or after order number 11. In view of the process that we are undertaking in terms of the Committee of the Whole House, where we were in the mid of concluding on the amendments by the Chair Committee on Energy, I request that Chair, in your intelligence, using order number 1, that you allow us to conclude that business, and then we can seek leave to deliberate on the motion by the member for Rangwe, so that for 45 minutes, just 45 minutes, and we'll be through. Honorable Chair, I seek your intelligence.
Honorable Beatrice Elaji.
Chair, I thought we had
the miscellaneous amendment bill, few sections, Honorable Speaker, and we thought we should dispense of this issue, which will not take more than 20 minutes, Honorable Speaker, and then we go into the Honorable Koko's motion,
which is also equally very important and touching the health of Kenya, Mr. Speaker. So I want to support my colleague, the Honorable Pukose, that you give us some few minutes, Honorable Speaker, and we should be done with the miscellaneous amendment bill. The committee of the whole House. Honorable, the adjournment motion was being brought by which member of the House? The Honorable Dr. Lillian Gogo. Would you approach the Speaker? So, honorable members, let me now put the question, which is that the House do agree with the committee in the said report. Will as many as are of that opinion say aye? Aye. Will as many as are of a contrary opinion say nay? The ayes have it. This is the ruling I will make in regard to the request made that we revert to the committee of the whole House. I've consulted the Honorable Dr. Lillian Gogo as we can accommodate the ongoing parliamentary business against the adjournment motion, which ought to have started, by the way, at 5. I'm therefore invoking the powers of the Speaker under Standing Order number 1 to review the previous ruling and direction of the Speaker on the starting time for the adjournment motion, which will now begin at 5:45, at exactly 5:45. And I'm saying I'm doing this having consulted both the majority sides that for the convenience of the House and for the due transaction of the businesses we have on the floor, we move that way. So the adjournment motion based on those consultations is moved to 5:45. The previous ruling of the Speaker in this regard stands revised to that extent. 5:45, adjournment motion will be moved. Let us revert to call order number 11 again.
Order number 11, Committee of the Whole House.
Honorable members, thank you. We go back to the Committee of the Whole on the Statutes Law Miscellaneous Amendment Bill, National Assembly Bill number 67 of 2023, and we had progressed up to section Sections 20 of the Energy Act, Cap 314. And honorable members, Chair, we can move faster than we were doing. So we proceed.
Provisions relating to the Energy Act, Cap 314.
Honorable members, I propose the question that provisions relating to the Energy Act, Cap 314. Okay, let's take it again so that we get the section.
Provisions relating to the Energy Act, Cap 314, Section 20.
Honorable members, I propose the question that provisions relating to the Energy Act, Cap 314, be amended as proposed in Section 20. Chair.
Thank you, Chair. I beg to move that the schedule to the bill be amended by deleting the amendment proposed to Section 20. The Honorable Chair had spoken to this, that the proposal by EPRA was to, currently the levies collected are supposed to be part of the consolidated fund. They wanted to remove that from the consolidated fund, and the committee's view is that it is more difficult to oversight funds that are given as A directly to institutions.
Honorable members, I propose the question that Section 20 be amended as proposed by the mover. Honorable members, I put the question that Section 20 be amended as proposed by the mover. Will as members of that opinion say aye? Aye. Will as members of the contrary opinion say nay? The ayes have it.
Section 26(4).
Honorable members, I propose the question that provisions relating to the Energy Act, Cap 314, be amended as proposed in Section 26(4). Chair. There being no amendment, honorable members, I proceed to put the question that Section 26(4) be amended as proposed in the bill. Will as many as without opinion say aye? Aye. Will as many of contrary opinion say nay? The ayes have it.
Section 45(1).
Honorable members, I propose the question that provisions relating to the Energy Act, Cap 314, be amended as proposed in Section 45(1). Chair.
Thank you, Chair. I beg to move that the schedule to the bill be amended by deleting the amendment proposed to Section 45(1). Honorable Chair, currently the CEO, REREC, serves as the secretary to the board. This particular amendment sought to remove the CEO as the secretary to the board and give the board powers to appoint anybody to serve as a secretary, which we find mischievous.
Very well. I propose the question that Section 45(1) be amended as proposed by the chair. I now put the question that Section 45(1) be amended as proposed by the chair. Will as many of that opinion say aye? Aye. Will as many of the contrary opinion say nay? The ayes have it.
Section 45(1)(e).
Honorable members, I propose the question that provisions relating to the Energy Act, Cap 314, be amended as proposed in Section 45(1)(e). Chair.
I beg to move that the schedule to the bill be amended by deleting the word 7 appearing in the amendment proposed to Section 45(1)(e) of the Energy Act, Cap 314, and substituting therefore the word 4. Members, again, REREC sought to increase the membership of their directors appointed by the Cabinet Secretary from 4 to 7. Meaning basically total number is 7. 3 currently are being appointed by the Council of Governors. They wanted to take everything. And we felt that since the representation by the Council of Governors is currently 4, while by the CS is 3, we are going to swap so that we have 4 from the CS and 3 from the Council of Governors. This will also speak to the next amendment.
I propose the question that Section 45(1)(e) be amended as proposed by the chair. Yes, Majority Leader.
Honorable Speaker, let me thank the chair and support that particular amendment because the chair did also not mention that this would be against the Mwongozo policy, because that would have moved the board membership from 9 to almost 11 members or 12, or way above the 9 recommended under the Mwongozo policy. Therefore, I support, and also it's also important that since the cabinet secretary in charge of energy is a person who has a lot more business to do than the Council of Governors, it's only right that we allow the CS to nominate 4 people and the Council of Governors nominates 3.
Very well, honorable members, I put the question that section 45(1)(e) be amended as proposed by the chair. Will as many as without opinion say aye? Aye. Will as many as with contrary opinion say nay? The ayes have it.
Section 45(1)(f).
Honorable members, I propose the question that provisions relating to the Energy Act Cap 314 be amended as proposed in sections 45(1)(f). Chair.
I beg to move that the schedule to the bill be amended by deleting the amendment proposed to section 45(1)(f) of the Energy Act, Cap 314, and substituting therefore the following new amendment: delete the word 4 appearing in paragraph F and substitute therefore the word 3. Again, you look at it carefully, we've just swapped the membership by the CS to 4, which was initially 3, and from the Council of Governors to 3, which was initially 4.
I propose the question that sections 45(1)(f) be amended as proposed by the chair. Honorable members, I put the question that section 45(1)(f) be amended as proposed by the chair. Will as many as of that opinion say aye? Aye. Will as many as of a contrary opinion say nay? The ayes have it.
Section 76(2), Section 82, Section 98(1)(d), Section 100(1)(b), 117, 129(2), 149(3), and Section 154(2).
Honorable members, I propose the question that provisions relating to the Energy Act, Cap 314, be amended as proposed in sections 76(2), 82, 98(1)(d), 100(1)(b), 117, 129(2), 149(3), 154(2). There being no amendments, honorable members, I now put the question that sections 76(2), 82, 98(1)(d), 100(1)(b), 117, 129(2), 149(3), and 154(2) as amended be part of the bill. Will as many as without opinion say aye? Aye. Will as many as without contrary opinion say nay? The ayes have it.
Section 166(3).
Honorable members, I propose the question that provisions related to the energy amended in section 166(3). Chair.
Chair, there should be some form of an error, and we have no amendment on 166(3, neither 166(4. Neither 167(1).
Honorable members, I put the question that sections 166(3), sections 166(4), and section 167 Could you confirm, Chair, that the amendments are not on only in the first two?
Even 167, 1.
Okay, I'll take it again. Honorable members, I put the questions that sections 166.3, 166.4, and 167.1 be amended as proposed in the bill. Will as many as of that opinion say aye? Aye. Will as many of the contrary opinion say nay? The ayes have it. Yes, Honorable Undo.
I know it might have been overtaken by events. I thought it would allow us to ventilate, but now that we have said. Honorable Speaker, if you look at the order paper, they providing for deletion. They have amendment on 166.3, 166.4, and 167.1. Honorable Speaker, but I hope the chair is listening. Can you seek, I want to seek the indulgence of the chair to listen.
Chair Energy. But you are very well set. The majority leader be there because listen to this.
Chair.
What is being said by Honorable Undo?
Chair, on the order paper, they have amendments to section 1, clause 166.3, 166.4, and 167.1. Is it the contentious or is it the pronouncement of the chair that the amendments have been dropped, or what is it are we talking about? It needs to go on record. Have they been dropped? It needs to go on record because there are no amendments. It's not the same as saying the amendments have been dropped.
Thank you, Honorable Oundo. Chair, could you go on record?
The amendments have been dropped.
Very well, we proceed, and thank you. Mike, we proceed.
Oh, sorry. Section 169.2.
Honorable members, I propose the question that provisions relating to the Energy Act, Cap 314, be amended as proposed in sections 169.2. Chair, there's an amendment on this one. 169.2.
Yes, there is. I beg to move that the schedule to the bill be amended by deleting the amendment proposed to section 169.2. Chair, it's a bit contentious issue here. That this particular one, the proposal was that if you, for instance, hire a vehicle or rent out your vehicle, and that vehicle is used to carry stolen materials, Kenya Power stolen materials like cables or etc., then you forfeit that vehicle. And the committee felt that it's a bit too, we are stretching it further, too far, because you can easily hire a vehicle without knowing the intent or the purpose for which this vehicle is going to be used, and you rent out your vehicle. This vehicle, if it ends up being used for other purposes, it will be a little too unfair that you forfeit a vehicle by just virtue of hiring this particular vehicle to the person who ends up using it for mischief.
Very well, Chair.
Yes, yes.
Let me propose the question first. Honorable members, let me propose the question that section 169.2 be amended as proposed by the chair. Yes, Honorable Bowen. Bowen, you take the first bite.
Yes, I think, I don't know why they deleted this clause, Honorable Speaker, because if you find a vehicle carrying KPLC stolen materials, it means these people, they have organized themselves. They organize including the car, the means of transport, and the whole thing is a scene of crime. So I don't know why the committee, they should not have been deleted. It should be a deterrent, because many of our transformers in the rural areas, they have been stolen, and they are not taken they are not using their bags, they are using vehicles. Even those vehicles are part of the conspiracy. So they should be forbidden to the state. I oppose.
Honorable Millie.
Thank you, Chair. Chair, even though I want to agree with Honorable Bowen that a lot of our communities are suffering because of the way people are stealing all our transformers and all that. But it would be really punitive if you were to punish the person who has hired out their vehicles. Because when you are letting out your vehicle, they don't tell you we are going to use your vehicle to steal. So really, what if you, in good faith, you give out your vehicle and then somebody uses your vehicle to steal? Even in criminal law, we must also be able to assess that you have a criminal mind or a guilty mind, which is called the mens rea. So it should actually be wrong to punish a person without a guilty mind. So I want to agree with the chair with that proposed amendment. Let us put strict punishment, but not punishing people who have not deliberately gone out of their way to steal.
Leader.
Chair, you know, the intent of this amendment was to make it punitive to carry stolen materials, especially those related to the energy sector. But I wanted to propose maybe as a middle ground, Honorable Speaker, that the chair considers, instead of deleting the entire amendment, to add a proviso where we say any vessel used to convey the vandalized equipment or appliance in the attempted vandalism detailed in subsection shall be forfeited to the state, provided that the owner of the vessel is not the person who was who is guilty of having vandalized the equipment. So that we have a proviso, Honorable Speaker, so that we also don't encourage people, because the intent of this amendment, Honorable Speaker, is to discourage even people who lease out their cars for transportation, but may not know what they are transporting. But also, Honorable Speaker, we also need, in view of what the committee is saying, to protect other innocent people, including yourselves, who your driver may take your car and ferry, and you're able to show that you never intended to transport stolen equipment knowingly. But if you knowingly transported stolen transformers and other equipment, then you forfeit that vehicle. And by the way, this is not the first proviso. Under the KWS Act, if you transport poached animals, you forfeit your vehicle. What was your vehicle doing in a game park? Ferrying elephant tusks. You forfeit the vehicle. If you slaughter antelopes in the game reserves, it is there. So we just need to correct it to have a similar proviso that is punitive and discouraging people from ferrying stolen goods.
The Honorable Masse, as the Honorable Masse speaks on this, Chair.
Thank you.
Order, Honorable Masse, could you consider then coming with a middle level? But let's hear Honorable Masse's contribution.
Thank you,
Very
Chair.
briefly, 1 minute.
Thank you, Chair. Chair, I want to support the position of the committee. Whereas I agree this is a very serious offense, and I must reiterate that the offenders, the thieves, must be punished, and there should be a serious clause for punishing the thieves. Because, Honorable Chair, I'm just from my constituency. So many cables have been stolen and my people are in darkness. So we cannot allow this to continue.
Very
Those
well.
who are stealing cables must be punished.
You have made your point.
But we should not punish innocent owners of transport.
You have made your point, Honorable Cliff.
Honorable Speaker,
Gisairo.
because even your vehicle can be hijacked and used to transport this cable.
You made your point. Gisairo.
Thank you, Chair. I think I support the deletion by the Chair because, Chair, if the car has been leased it will be wrong to punish the owner, for he may not have been aware that the car will be used for that.
Okay.
Yes, while we are against the stealing and vandalizing of electrical materials in our constituency and in the country in general, those who can forfeit, if, let's say, you are using your own vehicle and you are part of the act of ferrying the stolen materials, then at that point, because you are a culprit, then at that point you should be able to forfeit.
Very
the
well.
vehicle. Thank you.
Very
Chair.
well. Finally, Oundo.
Chair, I think the committee chair needs to be very careful in what they are amending. Honorable Chair, the Parent Act has a provision, has that particular clause, which says any vessel used to convey. Now, there was an amendment to expand it and make it more neater and tidier. Now, by proposing to delete the proposed amendment, it therefore means whatever exists in the Parent Act remains. See, we must be very clear. What are we saying? If the intention was to delete it completely, then you cannot proceed by how it is stated in this order paper. It means the existing clause or section remains, which is, and I thought the amendment as proposed in the miscellaneous bill was more elaborate and was capturing a little more issues compared to the existing clause, existing section. So the chair needs to be very clear.
Very well.
I want to be very clear that by deleting the proposed amendment, we revert to the existing section.
Very well.
Thank you.
Honorable Muchomba, and then Chair.
Chair, I am just wondering why we are wasting a lot of time to try to make a law that is going to be prohibitive for business people to lend out their cars or lease out their cars.
Honorable Muchomba, this House does not waste time. Mind your language, proceed.
Okay, Chair, I am thinking that even in as much as we support the proposed amendment, we should come up with a way of making sure that we create trackers that can be fixed inside the transformer and anything that is relating to that item, so that even if it is stolen, you don't have to be punishing the owners of the vehicle who were involved in transportation, but generally come up with a system of tracking the item.
Very
so
well.
in as much as we support him on that, because we don't want to lose the transformers again, let us come up with a way of tracking the equipment itself, because trackers are there.
You have
in
made
Kenya.
your point, and you are fallen on one part of the divide. Okay, Chair, do you have a further amendment to this? Yes. Okay, proceed to move that further amendment. And that means, honorable members, you have been heard. Boyen, who do you want to inform?
Inform the House, Mr. Speaker, that even as we encourage our transporters, Mr. Speaker, Mr. Chair, it is good for them also that before they lease out their trucks, they need to understand what they are hired for. So that we need to have, as a country or the Association of Transporters, they should have a kind of a form. If I hire your vehicle, you need to tell me, what am I going to carry your vehicle?
Very well.
So that now, I don't say I'm going to carry cabbages or vegetables, and then I'm going to carry a transformer from a village.
Honorable Bowen, that's enough. You are only informing the House because we had a gap. Now, Chair, could we get your further amendment? We had exhausted that bit, my two honorable members. I see you clearly, but we had actually finished with that business. Chair.
So thank you, Chair. It's a further amendment on section 169(2).
As I now put the question, of that opinion, say aye. Aye. Will as many of the contrary opinion say nay? The ayes have it. Proceed. Honorable members, I propose the questions and provisions relating to the Energy Act Cap 314 be amended as proposed in sections 187, 199.1, 208.1. Honorable members, there being no amendments to this one, I proceed to put the question that sections 187, 199.1, 208.1 be amended as proposed in the bill. Will as many as without opinion say aye? Aye. Will as many as with contrary opinion say nay? The ayes have it.
Section 216.1.
Honorable members, I propose the question that provisions relating to the Energy Act Cap 314 be amended as proposed in section 216.1. Chair.
Chair, I wish to drop that particular amendment.
And therefore, what does that mean? Because I know you will get a question from Honorable Undo. Proceed.
Yeah, the Act establishes a fund called the Consolidated Energy Fund. The proposed amendment was to delete the word consolidated. It is erroneously put as a part of the committee amendments because we agree with the ministry, because the word consolidated brings about confusion from the consolidated fund from the perspective of Treasury. That's fine.
Honorable members, I propose the question.
It will remain as energy fund. Yes.
Honorable members, I propose, give me the mic. Honorable members, I propose the question that section 216.1 be amended as proposed in the bill. Let me hear, Honorable, just one comment there.
Thank you, Chair. I support the Chairman on that amendment that we call it Energy Fund instead of Consolidated Fund. Thank you, Chair.
Honorable members, I put the question that section 216.1 be amended as proposed in the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. Next. Honorable members, I now put the global question, which is that provisions relating to the Energy Act Cap 314 as amended be part of the bill. Will as many as without opinion say aye? Aye. Will as many as with contrary opinion say nay? The ayes have it.
Provisions relating to the Private Partnership Act, number 2021, number 14 of 2021.
Sections?
Sections 29.3, 48.2, 55.4, 73.7, and 75.5.
Honorable members, I propose the question that provisions relating to the Private Partnerships Act 2021, number 14 of 2021, be amended in sections 29.3, section 48.2, section 55.4, section 73.7, and section 75.5. Honorable members, there being no amendments, I put the question that sections 29.3, section 48.2, section 55.4, section 73.7, and section 75.5 5655 be amended as proposed in the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I now put the global question, which is that provisions relating to the Private Partnerships Act 2021, number 14 of 2021, be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Provisions relating to the Parliamentary Service Act, number 22 of 2019, sections 3, 5, and 18.
Honorable members, I now propose the question that provisions relating to the Parliamentary Service Act number 22 of 2019 be amended as proposed in sections 3, sections 5, and section 18. There being no amendments, honorable members, I proceed to put the question that sections 3, sections 5, and sections 18 be amended as proposed in the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I proceed to put the global question, which is that provisions relating to the Parliamentary Service Act number 22 of 2019 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Provisions relating to the Judicial Service Act, number 1 of 2011, section 13.
Honorable members, I propose the question that provisions relating to the Judiciary Service Act number 1 of 2011 be amended as proposed in new section 13. There's no amendment. I proceed to put the question that provisions relating to the Judicial Service Act number 1 of 2011, new section 13 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the global question that provisions relating to the Judicial Service Act number 1 of 2011 be part of the bill. Will as many as of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Title.
I propose the question that the title be the title of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 1.
I propose the question that clause 1 be the clause of the bill. I now put the question that clause 1 be part of the bill. Will as many as of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. Honorable members, that's the end as the Speaker had instructed, and the time now being just 1 minute to 5:45. Mover.
Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Statute Law Miscellaneous Amendments Bill, National Assembly Bill number 67 of 2023, and its approval thereof with amendments.
Honorable members, I put the question, which is that the committee do report to the House its consideration of the Statute Law Miscellaneous Amendments Bill, National Assembly Bill number 67 of 2023, and its approval thereof. Very well, Honorable Speaker. Honorable Speaker, I beg to report that the Committee of the Whole House has considered the Statute Law Miscellaneous Amendment Bill, National Assembly Bill number 67 of 2023, and approved the same with amendments.
The mover to move agreement with the report.
Honorable Speaker, I beg to move that the House do agree with the committee in the said report. I also request with the report of the Committee of the Whole House.
Thank you, Honorable Speaker. I second.
It's good to be experienced majority leader. Honorable Karamba is now an old hand in parliamentary procedure. Honorable members, I now propose the question, which is that the House do agree with the committee in the said report. The Honorable Millie Odhiambo, the minority whip, wants to speak to this. Okay. Yes, the Honorable Majority Leader.
Honorable Speaker, I know this bill has taken quite some time because of the enormous work that was involved with the various committees, and allow me to take this opportunity to thank the Chair Energy, our Chair Labor, the Honorable Karemba, the Chair Jailak, and I think the other chair was the Chair for Sports, who are very diligent in all the work that they put in considering these amendments. Honorable Speaker, particularly allow me, Honorable Speaker, to now tell our judicial officers, Honorable Speaker, that in accordance with the mandate that was conferred to the Judicial Service Commission by Articles 172, 1B, and 251D of our Constitution, the Commission can now review and determine the nature of transport facilitation and the rates of reimbursement of daily subsistence of expended by judicial officers, from judges, other judiciary staff, Honorable Speaker. And you know, our judiciary and judicial officers, including our judges, all the way from the judges of the High Court to judicial officers in lower courts, all the way to magistrates, have suffered for some time because they have been subjected to the vagaries of the Salaries and Enumeration Commission, Honorable Speaker. But in accordance with the provisions of the articles I've mentioned, Articles 172, 1B and 252, 1D, the Judicial Service Commission now can review and determine what facilitation befits a judge of the Supreme Court, what facilitation befits a magistrate in a far-flung corner of our country where the road network is not very good and they are not being facilitated by the state to serve the people that they are serving in those jurisdictions. And with the amendments in this miscellaneous statutes amendment bill, Honorable Speaker, it will now be possible for the Judicial Service Commission to do that, to facilitate the efficient working and delivery of justice to Kenyans across the country. Of course, I hear whispers about what about members of parliament. The Parliamentary Service Commission, Honorable Speaker, does the same. It determines the remuneration or the facilitation to be able to facilitate your movement. But probably I should take this opportunity, Honorable Speaker, to remind the Parliamentary Service Commission that those members of parliament from Nairobi and areas surrounding Nairobi, like Kikuyu constituency, those from Machakos, those from Murang'a, those from Kiambu, and parts of Kajiado, Honorable Speaker, are still not being facilitated, and they also spend a lot of their resources to attend to their constituents, and therefore, Honorable Speaker, the Parliamentary Service Commission and our commissioners, they are those commissioners we elected in this House, particularly, Honorable Speaker. And we told them part of their core responsibility will be ensure that there is equity in the facilitation of transportation of members of parliament. We are in the third year of this House, Honorable Speaker, and we are serving them notice that they must meet the expectations of those members of parliament who are from the vicinity of parliament or constituencies and counties that are nearer Nairobi, Honorable Speaker, so that there is equity, Honorable Speaker. And with those many remarks, I support and thank honorable members for your commitment to be here up to this time in support of this bill. Thank you, Honorable Speaker.
Honorable members, under our standing orders, adjournment motions have to be moved when the time directed by the Speaker comes. That was to be about 4:45. I gave opportunity to the majority leader because of his position in the House. Would you give the mic to the mover of the adjournment motion to move? The Honorable Dr. Lillian Gogo, the MP for Rangwe.
Adjournment of the House to discuss the implementation of the Social Health Insurance Fund.
Dr. Lillian Gogo.
Thank you so much, Honorable Speaker and honorable colleagues, for coming to discuss this matter that is of national importance. Honorable Speaker, healthcare is a basic right, and a healthy nation, Honorable Speaker, speaks to the development and progress of that nation. Social Health Insurance Fund is designed to improve universal...
The Honorable Lillian Gogo, would you first move? Just to the extent possible. I know the motion is in terms of what was approved. You don't have to read the whole of it, but if you can pick so that you move.
I was just doing a component. I was just about to finish. Thank you, Honorable Speaker. The objectives are commendable as it aims to bridge critical challenges and it is important that we look at this as a matter of national importance. I beg to move, Honorable Speaker.
Yes, so proceed. Proceed, you had moved.
Oh, thank you so much. Honorable Speaker.
Members from the beginning, the Honorable Dr. Lillian Gogo, you have 10 minutes.
Oh, okay.
All other members have not more than 5 minutes under the standing orders. So proceed.
Thank you very much. Honorable Speaker, it is usually the desire of every government to provide health care to its citizenry. And as it were, Honorable Speaker, there was need to change from the National Hospital Insurance Fund to what was presumed to be a better quality healthcare system, the Social Health Insurance Fund, SHIF, that is to be managed by the Social Health Authority. One, there are so many aspects that are brought, Honorable Speaker, and citizens are confused. They don't know whether it is NIF, they don't know whether it is SHI, they don't know whether it is SHA, they don't know whether it is SHO. People need to be appraised. Shisha, no, not Shisha. People need to be appraised on this matter. It affects their health. Honorable Speaker, in my last salary, 32,000 and some other shillings were deducted from my salary. One, this caused delay, but it eventually went. And I'm told that those who are not able can pay as low as 500 shillings and still get health care. But the challenge that I have, Honorable Speaker, that is making me raise this matter is these monies, do they go to the ground, Honorable Speaker? Do they go to the intended persons, Honorable Speaker? Honorable Speaker, how much has this particular program allocated for the purchasing of equipment, Honorable Speaker? How much, Honorable Speaker, has this program put aside, this health insurance, how much has it put aside for the training of healthcare workers, Honorable Speaker. We have seen our highly trained doctors and nurses. We have seen our highly trained doctors and nurses being encouraged to go and look for jobs abroad. As much as money is gotten from my salary, the concern that I have, Honorable Speaker, is that does this money reach a poor woman who is going to deliver at the Rangwe Sub-County Hospital? That is my concern, Honorable Speaker. Another concern that I have, Honorable Speaker, is that there should have been a smooth transition. There should have been a 6-month transition. People should have been sensitized. But because of issues of trust, the citizens, Honorable Speaker, are refusing even to register in this social health insurance fund. They are refusing. It has not been explained well to them why they need to pay for it. And the money's delay, Honorable Speaker. When you go to the hospital, you are told that you have not been transferred to SHIF. I get messages on my phone saying that I've been successfully transferred to SHIF. Now, am I successfully transferred to SHIF because probably I'm a member of parliament, or do the other normal citizens, Honorable Speaker, do they get the same messages? And if we are able to do that, why not do it for everybody? Why not do it so that people don't go to our hospitals and they are turned away, Honorable Speaker? And the persons who suffer most, Honorable Speaker, are the women. The persons who suffer most, Honorable Speaker, are the caregivers. More often than not, caregivers are women. And they have to take care of children. They have to take care of the vulnerable, people with disabilities. They have to take care, Honorable Speaker, of the elderly. Sit as a community. If we don't sit as lawmakers, if the executive does not think, rethink, change of policy, and the gaps that it creates, and how these gaps can be covered, the person that suffers, Honorable Speaker, is the grass. And the grass is the mother of Akinyi and Adhiambo. Honorable Speaker, allow me to say this. I think we are taking Kenyans for granted, Honorable Speaker. Honorable Speaker, I think we are also creating unnecessary positions to benefit those who are elite in our community. We have the Social Health Authority. If up to now, as I'm speaking, the rollout was 1st of October, and we are almost advancing into November, what is this authority doing to make sure that as many as possible are registered? I went into a registration camp, Honorable Speaker, in one of the counties. As people were registering, there were clerks. And as they were being registered, if you say, Honorable Speaker, there were 2 options among the places that were to be filled. Do you live in a rental house? Do you live in your own house? Or do you pay rent? That is the question that you are asked. Corner the citizens. They hide these questions to corner the citizens, Honorable Speaker. When you say that you are paying rent, then it means that you are salaried, and they go for your salary. You're staying in your own house, then they put you in a category of people who are paying less. Why can't we have a foolproof system, Honorable Speaker? Why don't we have a system that moves smoothly, Honorable Speaker? Honorable Speaker, it is my concern. It is my concern that we are failing most sectors of our economy. But the one is healthcare. All of us today are seated here, Honorable Speaker, because for one reason or another, or by grace of God, we are well. But if you go to our hospitals, Honorable Speaker, people are writhing in pain, absolute pain. And with the increment of cases of cancer, Honorable Speaker, I'm so shocked that right now, the middle age are getting cancer even the more, Honorable Speaker. How are we going to take care of our young people, especially if we have a healthcare system that cannot be rolled out smoothly? Besides that, Honorable Speaker, we have a healthcare system that cannot make money reach where it is intended to reach. Private hospitals provide a substantial amount of assistance. Thank you for the 30 seconds. Private hospitals provide healthcare, Honorable Speaker. These are people you can never negotiate with. But when our people go, they are turned away. When they go to public hospitals, they are turned away. Where will the Kenyan poor, Honorable Speaker, go to? As a member of parliament, I go to the constituency. I am told by my teaching community, I am told by the elite of the community, please talk about she, sha, show. I thank you.
The chair of the departmental committee in charge of health, the Honorable Dr. Pukose.
Thank you, Honorable Speaker, for giving me to contribute to the issues which have been raised by Honorable Lillian Koko. First and foremost, I think it is good that we understand what we are talking about. The authority is called Social Health Authority. And this authority, that is the SHA. This authority was a creation of this House. It runs 3 funds: the Social Health Insurance Fund, the Emergency, Chronic and Critical Care Fund, and the Primary Health Care Fund. All the 3 funds now replaced the one fund which we had, the NHIF. NHIF had a lot of many problems and challenges. And the previous governments have tried to see how best we can be able to introduce the universal health care. We had pilot projects in Nyeri, Machakos, Kisumu, and other areas to see how we can be able to introduce this. When President Ruto came into government, he brought bills to be able to operationalize how can we be able to achieve universal health care as one of his projects, as one of his agendas in the manifesto of UDA and Kenya Kwanza. In this, we passed the Digital Health Authority, Digital Health Bill. We passed the Social Health Insurance, the Social Health Authority Bill, and we also passed the Primary Health Care Bill and also the Facility Improvement Fund. Honorable members, on 1st October, the government began rolling out this program on providing of Kenyans universal health care. It is 5 weeks now. In this program, as we speak today, we have several successes that we've seen. Among them, we have 39,000 Kenyans who have attended renal care visits. We have 81,000 Kenyans who have had admissions, 12,000 cancer care visits. We've had 49,000 consultations at the primary care. And what is the impact on this? That we've had renal and hemato-oncology, 430 million approved for life-saving dialysis care over the past 5 weeks. We've had more than 300 million approved for cancer care. The average turnaround time for pre-authorization has now improved. Initially, we had challenges, but as we speak today, the turnaround time is 2 hours. We've had challenges in terms of private hospitals, in terms of accepting and running this program. But in the 4 major hospitals, referral hospitals, that's the Moi Teaching and Referral Hospital, Kenyatta National Hospital, Kenyatta University Teaching and Referral Hospital, Madare Hospital, spinal injury, all these hospitals, as we speak today, there is no single patient who has gone there and been turned away. NHIF had a lot of challenges. In it, we had close to 12 million as beneficiaries of NHIF. Out of that 12 million, when the system was connected to the National Registration Bureau, 9 million Kenyans were found to be able to be transferred from the NHIF system to the SHA system. And that is where you got messages telling you that you are now transferred to the Social Health Authority. You can access Social Health Insurance Fund, which you contribute about 2.75, while the primary health care fund is fully funded by the government yourself. This might be a very small amount compared to when you become sick. And when the social health letter so that at every constituency office, you can now register people so that it is possible for you not to register at the time of seeking treatment, but to register in advance so that when you just go to the hospital, you're already a registered member. If I can ask for just one more minute, Mr. Speaker. So this is important, honorable members, because you have indigents. You have people who cannot be able to pay, and these are the people who expect the government to pay for them. Therefore, by registering within your constituency or within the women reps or even the senators' offices, we can use the means testing to identify.
1 minute because of the information is giving being committee chair.
The Social Health Authority, together with the Digital Health Agency, will send their staff so that they can liaise with your constituency office managers and your team so that your constituents can be registered, and through means testing, we can be able to pick those who are indigents and they can be able to access services so that the government can pay for them. Because in our budgetary allocation, we have an allocation that we allocate for indigents. And I think these are the largest population that will come to you seeking for your assistance. So as soon as that letter comes, I'll be able to forward to and we have asked them to forward to the clerk so that all members can be informed and you can be able to inform your constituents. With those few remarks, Honorable Speaker, thank you for allowing me to contribute.
The Honorable Dr. James Nyikal.
Well, okay, let me use. Thank you, Mr. Speaker. Mr. Speaker, we have a problem. And the basic problem is a problem of transition. So when we actually passed these bills, remember our greatest argument was actually on the issue of transition. So what has happened and why SHA and SHIF actually have gotten into problems is the transition, we didn't manage it well. And even when we said SHA, the authority which has got 3 funds. The Social Health Insurance Fund, SHIF itself, is okay in bit because of the people who are employed and therefore easy to catch. What about people who are self-employed? What about the indigents? What are we able to do to them now? And that is where the problem is, because they can register. And even when they register, then you have to determine the premium they have to pay. As it is now, that is not working well. You will say I'm registered, but how much premium am I supposed to pay? It does not come quickly. And then even when you get the premium, the existing ERP that is supposed to help you how to pay is also a problem, which has been a problem even for employed people, but that is now improving. So those are the problems. So now, those who are self-employed, we are saying we are going to use means testing. They test themselves. Now, when people give this data of their employment and you say, okay, you are supposed to pay this much, how do you verify that? And are they able to pay now? and what is the system of payment. That actually is still a problem. When we talk of the indigents are people who cannot pay. And let me say this, you cannot do proxy means testing online. All over the world, nobody has ever done proxy means testing online. Income of the family. You have to go and see what form of turnout. You cannot say this is a mabati and not a thatch. It is maybe some tin shack mabati. So you have to do that. We have a problem there. It is exactly the same problem we have with university funding. So we really have to go for proxy means testing and do it the way it should be done. We can use the community health promoters, but so far, and even the chiefs and the assistant chief, but so far, at least in my constituency, I've not really seen this thing working. So that is exactly where the problem is. And even these who are to assess themselves. So now, what has happened, because we have gone up in the payment, those employees who are paying a lot more now are actually covering up. What about those who are self-employed and have not enrolled, and you have not know how much they enroll? And now I know when we tested this way in Eldoret, they actually, you can get and say it is registered. You are registered, you have not paid, but because you are in a hurry, we are saying you can go and get the service. Now, if you are getting the service, you have been registered, but you haven't paid. What is going to encourage you to pay? So we have problems, and the system we have put in place, it affects everything from registration, premium determination, payment of premium, benefit package. Even the benefit package, we went up because we were expecting more money. And in the primary care fund, the emergency fund, we actually were expecting 70 billion, say 75. We have done 4 and 2, as my colleague is saying. But you know, the services, the benefit package we gave was based on that. So if that has not come and we are giving the services, where is the money coming from? If we don't do it and it is working efficiently, what is going to happen is very soon we are going to run short of money because we have not got that fund in. We have not enrolled people who are self-employed. We have not even identified the indigents. But because we want things to look good, we have
The Honorable, the Majority Leader, because of President.
Thank you, Honorable Speaker. Honorable Speaker, let me first take this opportunity to thank the Honorable Dr. Lilian Gogo for this adjournment motion, because it gives us the opportunity to address a very topical issue in our country. Honorable Speaker, maybe allow me to start with a bit of statistics that I have just gathered, Honorable Speaker, that so far, a total of 14.4 million Kenyans have registered to join the Social Health Authority program under the Social Health Insurance Fund. Out of this, today alone, I've just confirmed from the CEO of SHIF that 104,000 Kenyans have registered today. And allow me, Honorable Speaker, to plead with us as members of Parliament and as the people's representatives to be at the forefront in encouraging, promoting the registration of members of the public into the Social Health Insurance Fund. It might be politically expedient and very politically correct to speak to the gallery of how things are not working, but as we speak to Kenyans on how things are not working, let us remember that Kenyans have charged us with the responsibility to make sure that things do work for them. It therefore doesn't help me. Remember St. Peter's health facility there that mushroomed into a big health institution largely from money stolen from NHIF. You remember the other small dispensaries you saw in Tharaka Nithi, in Meru, in Nakuru, and people are hemorrhaging resources from NHIF, Honorable Speaker. It is these hemorrhage resources from NHIF today, Honorable Speaker, that largely are fueling the propaganda you see being peddled against the Social Health Insurance Fund, Honorable Speaker. Today, Honorable Speaker, out of the 14.4 million Kenyans who have registered, 710,000 have done the mean testing score. And out of these people, Honorable Speaker, when you register, Honorable Speaker, and these are the things we need to be telling to members of the public. The moment you register today are telling us that the mean premium that done the mean testing score of this 710,000 is 525 shillings. Because it is politically expedient, and for me as a business person who is well-meaning, who is doing well, to do the mean testing score, and I'm told the premiums you should pay from your level of income, and also people to know that it is based on how you answer the questions that are on that mean testing score. If you own a car that you are paying insurance of 200,000 shillings, for heaven's sake, if you can insure an automobile, you can also. And therefore, Honorable Speaker, you find people who are quoting very huge figures. But because of the answers they gave as they did the mean testing score, fact, Honorable Speaker, and these are statistics that you can examine and see and authenticate from the SHA website, Honorable Speaker. The mean premium out of the 710,000 people who have registered is 525. Out of the service providers, Honorable Speaker, 7,802 hospitals have signed up for this program. Honorable Speaker, there are a further 8,118 healthcare providers who have successfully registered to offer services, and out of this, Honorable Speaker, 7,965 have offered services under shift to Kenyans. Therefore, for us to stand here, Honorable Speaker, in this house and elsewhere, in funerals and everywhere, to say, oh, it is not working, we are lying to Kenyans, Honorable Speaker. We should be telling Kenyans the truth. We should be educating Kenyans. And I know we may have failed in our communication strategy. We may have failed in how well we communicate and educate our people. But, Honorable Speaker, let us use this opportunity on this floor this evening to educate our people and let them know. Honorable Speaker, it is not fair that my constituents, who some are people who are unemployed, were paying an average of 500 shillings at a time with my huge salary, Honorable Speaker, besides my business income, Honorable Speaker, and that salary is paid for by the same constituents that I was paying 1,700 shillings a month. And now, because I'm being asked to pay 27,000 or 20,000 shillings a month, I start complaining and cry more than the bereaved. But I'm not being honest with Kenyans to tell Kenyans I am crying more than the bereaved because I am more bereaved because I am paying 20 times more than what I was paying from money that is paid to me by Kenyans. That is the kind of honesty, Honorable Speaker, I want to beg that we exercise as we debate, Honorable Speaker, as we educate. Let us be at the forefront of offering civic education to our people. Because, Honorable Speaker, you have seen cases of cancer patients. You've seen renal care patients, those who are undergoing dialysis, and yet I had paid for all my NHIF. If you are unemployed, the moment you sign up, automatically you can access a level 1, a level 2, a level 3 hospital without payment. The capitation that is going to the hospitals, the Facility Improvement Fund. You know, I was so embarrassed, Honorable Speaker, over the weekend when I had a member of parliament pretend in Kikuyu that this chief or shifo, and saying it is not this shifo. Shifo is a name for a chief. A member of parliament saying that they do not know the difference between chief and shifo. Yet, you are seated in this house, you legislated right from the first reading to the third reading to the committee of the whole house. You are here shouting aye, as the speaker said, the eyes have it. Then you go to your village to tell Kenyans that you do not know the difference between chief and shifo, that you do not know the difference between sha and chief. Honorable Speaker, I am saying I was so embarrassed because I would expect a leader elected by the people believing that that leader knows more than them, to be using that opportunity, Honorable Speaker, to educate their people, to tell them that if you have need to access renal care and dialysis at your dispensary or at your local level 4 hospital, all you need to do if you are unemployed is to do the mean testing score. You are advised how much premium you should pay. When you pay, Honorable Speaker, and I know these are the cries that Kenyans have raised, that the mean testing score is asking you to pay for the annual premiums for the whole year. That was the case under NHIF. You could not access renal care, cancer treatment, without paying your annual premiums, Honorable Speaker. And Kenyans were paying. Today, Honorable Speaker, because SHA, or the Social Health Authority, is yet to activate the insurance premium financing, they have now opened it up to Kenyans to be able to pay every month. Let us educate our people that you now can pay monthly premiums, access your dialysis, access your cancer treatment. Let Kenyans know that today under SHIF or under the Social Health Insurance Fund, they can access dialysis, they can access chemotherapy, radiotherapy, free of charge if they are registered with this authority, if they have paid their premiums. Doesn't matter whether it's annual premiums. If you have access to insurance premium financing to pay your annual premiums, pay. If you cannot, discuss with them and pay your monthly premiums. Access those services. Honorable Speaker, my last point. Our county governments and our county governors, and I really want to plead with our county governor.
A minute only.
In a minute, Honorable Speaker, if our CEC's healthcare in our counties can take up the challenge, because other than the Kenyan public who are the major beneficiaries of this shift, Honorable Speaker, is our county governments. The Facility Improvement Fund that we legislated in this House, I know many politicians will not tell Kenyans that truth, that facility improvement facility empowers your local dispensary to have a committee that will even procure equipment and medicine at that local level. It is the number of people who are registered in that locality and who are registered to that facility that will enable the facility in your locality to access the Facility Improvement Fund that will ensure that a hospital in Gatuna in Kikuyu, the far-flung corner of my constituency, the most remote part of my constituency, if they have a dispensary, Honorable Speaker, they will be able to access the Facility Improvement Fund, be able to equip their dispensary, have medicine available at the dispensary, have money to hire doctors, and we legislated, we made it possible in this House, Honorable Speaker.
Thank you, Majority Leader. The Minority Leader will take precedence over you, Honorable Andrew Kwome. The Minority Leader will take precedence over you, the Minority Whip, for the avoidance. The Minority Whip.
Thank you, Mr. Speaker. And I want to thank Honorable Lilian Gogo.
Honorable Millie will always speak before you whenever she wants.
Though that is discriminatory because the tallest man should be speaking before. But Mr. Speaker, having said that, I want to thank Honorable Lilian Gogo Honorable Dr. Lilian Gogo for bringing this before the House. And Mr. Speaker, I just want to say that under Article 43 of our Constitution, Mr. Speaker, I was in the House when those bills were being passed. I was especially opposed to certain parts of that bill, but that is now what under the bridge we have a new legal framework. Mr. Speaker, having listened even to the members, the honorable members as they move, Honorable Kimani Chungwa and even the Honorable Nyikala and the Chair of Health Committee, one of the things that I can indeed say is that the proof of the pudding is in the eating. So it is actually too early to even say, we would be cheating ourselves to say that here are the benefits. We don't know the benefit yet. If you are an excellent person at monitoring and evaluation, you cannot say within a month that we can see the benefits. So yes, we will probably see the benefits much later. However, we can see photos of people who are in hospital. Mr. Speaker, even though I know Honorable Ichungwa is actually castigating a lot of the members who he says are pushing propaganda. As the, oh, he's saying one. I don't know who that is, since I'm not too sure about, I'm not very keen on the politics of the mountain. But Mr. Speaker, what I want to say is that we need to acknowledge that there are very serious transition issues over this. Over this. And Mr. Speaker, if we lose a life, we can never regain it. I have a person who is very close to me who is undergoing cancer treatment right now and will not receive any treatment unless there's pre-authorization of payment. And Mr. Speaker, if me, I'm at the place where I am, maybe because they are able to do that, because we, for different factors we can. But the cries we are getting from our own constituencies, the cries we are getting from ordinary Kenyans is telling you that there's a huge problem with the transition. And this transition was not done efficiently. What I would want to encourage the chairman of the Committee of Health is, one, please do a kamkunji for members of parliament. I am a lawyer and I was here when this was passed. And a lot of us would want to sit here and pretend that we understand and know. Me, there are a lot of things I don't understand about this, and I passed this law here. What about ordinary Kenyans? Do an urgent kamkunji for members of parliament so they understand what this system, this new system is all about. Number two, we need to actually stop most of the things we are doing in this country so that members of the public understand and know how they can access healthcare. Because healthcare should be the most primary, right for everybody. Because if I'm already dead, how are you helping me? How will it be of benefit to me if I'm already dead? Even if you were to compensate, I will already be dead. So really, I think we need to take this issue more seriously than we are. Let us listen to the cries of Kenyans. If the health system is not working, a lot of the poor people can't access healthcare system, there is a problem. And Honorable Majority Leader, please listen. Please, the transition is not working well. Please take this and inform whoever needs to be informed that they need to take urgent action. The transition is not working well. Thank you, Lillian, for bringing this.
I would request we speak for not more than 3 minutes so that as many of us as possible contribute. The Honorable Omboko Milemba. I have not recognized you.
Thank you, Honorable Speaker. The issue concerning the new model of health provision in this country requires a consortium of all of us to deal with. It doesn't require even people to take podiums on one side and say that this is succeeding, while another team sits on the other side to say it's succeeding, because that will not help us. Another thing I want to say about this is that it doesn't even require statistics, quick statistics of we have treated several number of people, we have done this dialysis. I'm seated very close to the chairman, and he gave a number of such statistics, but even the leader of majority went ahead to give a lot of statistics. I was in a meeting over the weekend where the Minister for Health was called upon to speak on this. Honorable Speaker, she went straight into statistics the way I've seen this happen here, and she lost it. But later on, another speaker came, took her time or his time and spoke about slowly. I was with the Honorable Maungu, and the second speaker really scored. So I really want to remove the first thing amongst members of parliament. There are those who are supporting, those who are not supporting, those who know, those who don't know. We don't know this thing properly. And we need to know it. If we don't know it properly, the local man will not know this thing. And therefore, because I know I have 3 minutes only, the first advisor is to go with Millie. Let's have a kamkunji. But I had another one, that we need to invite the Minister of Health in this particular assembly so that he may explain to us what is happening outside there. Because unless the explanation comes out, it will be difficult. Honorable Speaker, the other challenge is the ownership of the whole setup. The Kenyans are not willing to own up this particular new model of funding. And the ownership can only be developed if us, the members of parliament, will go outside there and explain. And also involve other parties. The chair here talked about is having people within this, and I've asked him informally here, that there are people around who can actually do the mean testing and actually register people. I'm telling you, Honorable Chair, that there are no people registering people in this scheme where I come from. And I have decided, since Sunday, I decided that I'm going to help. So for me, I'm going to go out flat to register all my constituents. But we have to involve other players. Let's not say that we have enough staff. Those CHPs, if they were trained to actually register people in this scheme, it would work. After all, they know everybody. They know the indigent. So even as we do the mean testing, they can actually add up to bring out the whole thing to work properly. And I think that's the direction we need to take with this thing. Otherwise, once the Kenyan person is complaining, we are not safe, even if we give whatever number of statistics. So for me, we need to own up this model, go and explain it, and use every other people within the circles to see how the model can work. Thank you, Honorable Speaker.
The Honorable Karoli Omondi.
Thank you very much, Honorable Speaker, for the opportunity, and thanks, Honorable Lilian Gogo, for bringing this matter to the floor of the House. I agree with the other speakers that the transition has been very bad in this particular matter. I mean, there are already patients with chronic illnesses who are already being served under NHIF. And I wonder why they just never made the full smooth transition into SHA. Because they were already covered, they're already paying their premium, they're already receiving the services. But today they are being asked to register again. And I think this is where the biggest problem is. So we would like to hear from those responsible why there was no bulk transmission of existing members under the previous insurance scheme who had current premiums. And to make matters worse, even those who are enrolling today, they're having difficulties making the payments under the system. It is quite a challenge. You go to hospital, you enroll, you try to pay, you don't go through. But, Honorable Chair, I think the most critical thing is that this new scheme is grossly underfunded, and it will not work unless the issue of funding is addressed. The data I have, and Omboko Mulema, please forgive me for using some numbers, NHIF legacy debt is over 30 billion, which is not paid to service providers. How will you convince them to start accepting new patients under the new system, especially the private sector hospitals? The actuarial projections were that about 50 billion would be needed to start underwriting the three funds that we have created. Only 6 billion has been made available of the 50 billion that was required. And as the majority leader said, 14 million members have registered, but only 700,000 have paid. And I suspect these 700,000 are those who have been captured because of employment, not because of being self-employed. Yeah, because they are employed. So basically, we are looking at a new system that is grossly underfunded, projected to cost about 275 billion in the long run to make it fully functional, but is funded at 6 billion. And to make matters worse, we have committed 105 billion to buy a health management software system, information system, 105 billion, instead of committing the money to underfunding the insurance schemes under this scheme. So I think the biggest problem is the way this thing is being funded. And without sufficient funds, I can guarantee you it will fail. It will not work. Thank you, Honorable Speaker. I think